Okay. Thank you so much. And thank you for having me. The specific topic that I'm to speak on is opportunities available to legal practitioners due to the devolution of constitutional authority over electricity generation, transmission, and distribution. And so that's what I'll be talking about today. I think this topic is enough to keep us speaking for a day, given the breadth of the subject matter. But I have only 20 minutes. So what I would try and do is to speak practically to the points of value that I think everyone is really interested in. Because when you speak about opportunities, I think what lawyers want to hear is how can those opportunities how can those opportunities translate to value for me if I am able to participate in that specific sector. So I'll try and keep my points high level. In the last 20 years, really, we have seen a lot of changes in the Nigerian power sector, starting from where we used to have NEPA, the Nigerian Electric Power Authority, coming on to Power Holding Company of Nigeria, and then the unbundling of the PHCN following the Electric Power Sector Reform Act in 2005. And the unbundling was in 2013, but the Power Sector Reform Act came in about 2005. And subsequently, we've had last year the amendment of the 1999 Constitution, which gave states the power to make laws with respect to generation, transmission, and distribution of electricity within their states. An interesting point on that actually is that sometimes we say that the states did not have power to make laws on generation, transmission, and distribution within their states. Not entirely correct, actually. The states had always, by virtue of the concurrent legislative list, had power to legislate on these areas, but the concurrent list limited that legislative power to areas that are not covered by the national grid. But if you typically look around you, you'll find that in the major areas, in the major cities, there's national grid connection there. And so what that meant was that it was of no economic sense for states to embark on any sort of regulation in those areas or legislation in those areas because they could attract the needed investment. Nobody will put here to a that is only designed to light up rural is being provided to those. Remove that connections in order to legislate on transmission, distribution, and generation, transmission, generation, and distribution within the entire area of the states, notwithstanding that there might be a national grid system within that area of the state. So it's a very simple amendment, which was the fifth alteration to the 1999 Constitution, but a highly effective one. I just also want to point out I had sent in a paper which I think can be circulated shortly after the webinar. So what I'll just try and do now is to give high level points of discussion from what has been written in the paper. Let's talk now about the legal framework of Nigerian electric power sector. As of today, the two principal, I would say, the legal regime is anchored on two principal legislations. The first is the 1999 Constitution, because that is what it delineates the government, the federal level, and the governments at the state level to be able to make laws with respect to the power sector in Nigeria. Speaking especially about the amendments that I had just referred to. And the second is the Electricity Act. The Electricity Act is important. It came into force in 2003. I think it was signed by the former President Muhammadu Buhari in the twilight of his administration. And what that law did was to repeal the Electric Power Sector Reform Act. And among other things, it consolidated the laws relating to the Nigerian electricity supply industry. That law provides a comprehensive legal and institutional framework for the power sector in Nigeria in the areas of electricity generation, transmission, system operation, distribution, supply, trading, and enforcement of consumer rights and obligations within that power sector. And if you see from section 1 of the Act, it states the primary objective of the Act to be to provide a comprehensive legal and institutional framework to guide the operation of privatized, contract and rule-based competitive electricity markets in Nigeria, and also to attract private sector investment in the power value chain of the Nigerian electricity supply industry through transformative policies. And so really what that act has done is to sort of help a little bit to simplify the regulatory landscape, because before now we had more than one legislation, so to speak, that you would have had to engage with in trying to understand how the Nigerian power sector was shaped up. And so I've said all these things just to set a scene for what the regulatory landscape looks like. I've tried not to go too in depth in that because, as I said earlier, it's a subject matter that can really take us down, a rabbit hole. But really, for the purpose of this conversation, it's sufficient to bear in mind the Constitution of Nigeria and the Electricity Act that came in 2003. So speaking about the key points of potential participation of opportunities for legal practitioners, I have about 5 or 6 general points. The first point is policy advocacy and legal reform. It's interesting to note that you have said the Delta State government has put in place an electricity law within the state. And I think that's the first step in that direction, because as far as we're speaking about lawyers within Delta State, if the state had not taken the step to do that, then really there's not much to talk about, because there is no field in which the lawyers can then go on and play. And so I think that first step has been taken in the right direction. What we then need to see is that energy policy making needs to follow. And so apart from the statute that has been put in place, policies need to flow from that. I'm sure that law may set up an electricity regulatory body, which would then set up regulations and guidelines and so on and so forth, which all form part of a general body of legal work that legal practitioners have to get involved in doing. Apart from that, there are sort of what I'll call tangential policy changes and reforms that need to be made, or even new policies that need to be introduced in terms of areas like land law, because you would need, in the course of setting up electricity plants, for instance, to purchase land and to set up plants. And so there are other connecting areas in which policy reform needs to be done. And so it should not be looked at from a policy perspective that the fact that the electricity law of Delta State has been enacted means that there's not much more to see in that area. There's a lot more to do in that area because it's an entirely green area now that then needs to be populated by applicable policy. The opportunity for legal practitioners in that area is that there is an opportunity to advise either the House of Assembly if there is any other law that needs to be made or amendments that need to be made into that law, if it ultimately turns out that that law does not meet the local requirements of Delta State for the purpose of trying to build out its electricity industry. When the regulatory body is set up, the opportunities for lawyers to work in that organization, because it will need a legal department. It may well be that in the constitution of it may be the board or the council, I don't know what it will be called within the law, that there will be requirements for one or two of those members to be legal practitioners. And so those are some of the things that people need to be thinking about to see how they can position themselves with respect to capacity and to profiles to be up for consideration for appointments to those sorts of positions. There will also be the opportunity to advocate for, because when renewable energy is growing and the advocacy for renewable energy to take a more prominent role in the energy outlook, not just in Nigeria, but also globally, is high. And so there's work on the policy side for advocacy to ensure that not only is the state looking at meeting its electricity goals through the traditional means, which is gas supply and hydro supply, but also through other means under renewable energy options, such as solar and so on and so forth. So there's work to be done in that respect as well, so that we can have a wider growth of the local electricity sector in the state. The second point I have is on regulatory and compliance advisory. This you can both sides. You can take it on the side of the regulator when the regulator is ultimately up and running, but you could also side of the private companies that need to engage with the coming to the state to do business in those areas. To this extent, the federal state level regulation. The fact that states can now make laws for transmission, generation, and distribution of the electricity within the extended the Nigerian electricity redundant, because under the Electricity Act, there's still some regulatory steps that need to be taken at a federal level, NERC, even when a participant wants to undertake any endeavor in the electricity sector at state level. And so it's important to understand the interplay between those two regulatory points at the state level and at the federal level. And so that's a point for lawyers to pay attention to, trying to build capacity. Environmental and safety compliance. There are points to think about under the Environmental Impact Assessment Act, the EIA, because when electricity plants, whether for generation or for distribution, are going to be set up, that regulation comes into play as well. So it's important to sort of equip us with the laws that are relevant to these areas when that advice becomes necessary from a regulatory standpoint. I move on to the third point, which is contract and licensing opportunity. It's good to understand the nature of contracts that are relevant in this area. And Mr. Etomi had spoken about the fact that then there will need to be contracts to be drafted, there will need to be contracts to be reviewed. One thing to think about is, and I think Mr. Etomi touched on that point, is that we have roughly 5,000 megawatts of electricity today, and we need about 200,000. But the actual fact is that we do have more than 5,000. We have somewhere in the, I don't want to mislead you on the numbers, but it's maybe roughly in the 20K region, that, as far as I know, that we have. But that electricity we do not see today, because by my understanding, the national grid is not in a position to be able to accept that level of electricity. What that means is that power is trapped somewhere and it's not being used. Liberalization of transmission, generation, and distribution of electricity within the states now means that the owners of that power that is not in use today now have a wider market within to which they can sell that power. And so they'll be looking for buyers to come and take that power off them, because the national grid cannot do so. One way in which that power will be sold would be on the basis of what is called power purchase agreement, a power purchase agreement. Power purchase agreements are used in a number of ways. They can be used for very large projects, but they can also be used in smaller respects. So they can be used in a way where you have residential clusters, which is like a large residential estate or an industrial park that needs to buy power from those who have it so that they can increase their power supply. In Lagos, for instance, you have some estates that are trying to get 24-hour power supply, and that is one of the things that they're looking at. There's an opportunity there because, as Mr. Etomi had said, majority of the work that we have now in the electricity sector, because it's such a specialized field, tends to be limited in the hands of the more experienced and established larger law firms in Nigeria or international law firms that have significant footprints in the country. But within the area of power purchase agreements, some of that work can be closer to you than you might imagine. Because as I said, if you're looking at a residential estate that wants to buy power, and as a lawyer, you live in that environment, or you know people that live in that environment, it's easier to compete for that type of work. And so the importance of building capacity to know how how electricity law operates can be more useful to you because you have better access to clients at that local level compared to in comparison with larger companies that want to do larger projects. There are also opportunities in energy generation and distribution licensing, because when the local electricity regulator comes on board, they will need to issue licenses to participants within the state. And so companies will need to receive advice on how to those licenses and how to comply with the requirements for grant of those licenses to them. There are also agreements such as and franchise agreements where lawyers can assist with negotiation between state government private companies for distribution and facilitating the of infrastructure and some other services. Point of potential opportunities, PPP, which we have tended to see in road infrastructure and construction before now. I think that we're likely to see a lot more opportunities come up in the public-private partnership space with respect to electricity. There was an effort in that regard in Lagos a few years ago with Enron, which was an experiment that did not succeed. I think that we'll see more of those types of come up again in the future at state level, especially on a power purchase arrangement structure. And so it's important for lawyers to try and understand how all of these arrangements tend to operate. There's infrastructure financing, which is very important because electricity infrastructure is very capital intensive. And so you're likely to find, especially for domestic players that want to enter into that sector, that they do not have the capital on ground to be able to embark on the projects that are necessary to be carried out within the sector. And so there's a lot of infrastructure, there's a lot of financing structuring that needs to be done within that power sector, which is set up a little bit differently to how we may understand traditional financing structures. And so there's work opportunities in those areas. Mr. Etomi had touched upon is dispute resolution. This, I think, has perhaps the lowest barrier to entry because, as I think has also been said earlier, litigation in particular, when I speak of dispute resolution, I think a lot of that focus is on litigation and also barriers. It's an area that most Nigerian lawyers are particularly familiar with. That's even what is taught in law school. And so it's important I think that in trying to enter into the practice area within the legal practice area and the power or electricity sector, it's good to develop our skill sets in resolution of disputes in that, because you are already you have half a leg in when to do so, because you already do disputes work. And so the target should be to upskill ourselves in the resolution of power sector disputes. As Mr. Etomi has said, because of the time constraints that businesses operate with in the power sector, a strong appetite for dispute resolution by litigation, because nobody has time to be in court for the next 10 years on a transaction that will cost all the participants money each day that the case is in court. And so we need to open our minds to opportunities in the spaces of arbitration and ADR mediation, so that when disputes come up in those areas, we can participate in them. Thinking about the disputes also, I would like to point out the fact that you have different types of dispute. And so we always imagine that because all the players in the sector are big players, that all the disputes are big international disputes that will eventually end up in London or Paris or wherever it is. We have metering disputes between consumers and power distribution companies. We have metering disputes between meter providers, some of which are local. We have local manufacturers and providers who work with distribution companies. And so that is another avenue for disputes to arise within the power sector. And so there are lower hanging fruits that practitioners who have no prior experience in that area can quickly come in to familiarize themselves with the power sector, and then sort of develop client goodwill in the area and sort of climb the ladder from then on to handle disputes of a more significant nature. There are also disputes in energy contracts, such as PPAs and other PPP arrangements that may exist, and disputes may arise out of them. There are consumer protection disputes that could arise. Consumer protection in this space could be with the FCCPC. It could also be with the Nigerian Electricity Regulatory Commission, the NERC, which has a consumer dispute resolution mechanism in place. Lawyers are relevant in each and every one of these processes. And it's an easy way to get a crash course in dispute resolution in the electricity sector. Because when you're going before the NERC dispute resolution panel to have disputes resolved, the material that you're interacting with are core electricity law issues, because they will either have to do with metering or billing type of disputes. And so those are places that I think opportunities exist for us to keep our eyes open to. There are regulatory disputes as well, arising from licensing issues, sanction issues, and so on and so forth. And so the opportunities there. It's easy to think about these things also from the point of view that a lot of the things that in dispute resolution, a lot of the things that we will interact with are matters that are typically familiar with. So if you speak about regulatory or licensing disputes, many lawyers already practice administrative law because they do regulatory disputes in other respects. And so there's some experience there also. So I think it's helpful not to think that have any prior experience whatsoever in that area. There is some experience. What we just need to do is to build on that experience and tailor make it a bit better to the electricity market or power sector, so that we can widen the scope of opportunities that come our way within those areas. I have another subject matter that says, that relates to the impact of the devolution of powers to the states on local governments and economic development. development. And so they can tailor the track in this respect as well, because rule of law is an important part of why investors would go into any market. They need to know that if I have a contractual dispute with any other party within that sector, I can have my dispute resolved within the courts. And so I think that one of the ways to create further opportunities for lawyers is to make sure that our local court systems work well. And I think that the NBA at the branch level has an important role to play in that respect. If business people know that if they sue within your courts, they can get justice quickly, they would want to come and do business in that area. And so it's important that we keep that in mind as well. Challenges and considerations for legal practitioners. I have that the regulatory landscape is still evolving, and it will continue to evolve as the state develop energy policies going forward. It is important for lawyers to remain agile, to be dynamic, and to continually update knowledge of the changing regulations so that we can advise our clients effectively and accurately. Breaking into the sector to tap into a lot of these opportunities that I have spoken about, it wouldn't be easy. There's no free lunch, as has already been said. But I think that there's some things that can be done to be able to break off some of that market share for ourselves, coming from the perspective of having limited or no prior experience in that area. The first thing is capacity growth. So attending webinars such as these, there's some courses that can be done online. Some of them are free, some of them are paid. Joining the sections of the MBA has been mentioned earlier, the section of business law in particular. It's also important also to notice the tangential areas of law that I have spoken about. And so talking about breaking into the practice of law in the power sector does not mean that when you come in, you will start advising on power purchase agreements and PPP agreements from day one. There are other tangential practices such as land law, criminal law, company law, and regulatory compliance, which a lot of us already do. Speaking of criminal law, for instance, there are a lot of offenses that are built in even before this devolution of power that were built into the Electric Power Sector Reform Act, the Miscellaneous Offenses Act, meter tampering, and so on and so forth, where criminal prosecution needs to be undertaken. So we need to build out some of those practice areas that we're well familiar with already. And from there, we can have a foot in the door and sort of move deeper towards the nucleus of the practice area more generally. I have also thought leadership. Knowledge is power, but it is also money when you're a lawyer. But if you have knowledge that nobody knows about, then you cannot convert it to tangible value, which is money. And so we need to think about ways that we can put our knowledge out there in a way that it comes back to us in value, as professional fees and so on. And what the internet has done today is that it has reduced the barriers to entry for us demonstrating thought leadership. Information these days is freely, quickly, and widely disseminated. And so I think it's worthwhile to devote time to writing high quality articles and think pieces and putting them online so that people can identify you with a certain practice area. If you are known to speak about the same subject matter authoritatively on a consistent basis, then it is likely that people will seek you out in that area. And soon enough, work will come to you in that area and you can be regarded as a sectoral expert in that area. There's also mentorship. Sometimes you can seek out those who have prior experience and expertise in that area and attach ourselves to them just to try and get some of the knowledge and experience that they have. As Mr. Etomi to, should I say, break into the power sector from the perspective of having no or little prior experience. Thank you.
Thank you very much, NSU. At this point, the floor is open for questions. If you have any question, could you indicate by raising your hand and directing the question to either of the speakers who intend to answer your question. So participants, you can raise your hands. And so we unmute you. Okay, Badebo. Okay, so Badebo, you can ask your question now and direct it to either of the speakers you want to respond to you. So, Badebo, can you hear me? Ask. Badebo, can you hear me? Okay, ask. Can you hear me, Badebo?
I can hear you. Can you hear me now, sir?
Yes, I can hear you. So you can ask your question.
Okay, so thank you very, very much for the sessions, Mr. Etomi and Leonard Silk, sir. Okay, so my question is for the Leonard Silk. So with regards to a law student seeking admission into the Nigerian Bar Association in 2025, what opportunities in the green economy and energy transition sphere that one can build capacity towards? Then secondly, for personal development in terms of contract drafting in the power sector, can you recommend a relevant text or authors that are known for giving proper precedence in the area of power and energy agreements, and what agreements really tend to occur in this sector? Thank you, sir.
Sorry, do you want us to take the questions one after the other, or when all of them are asked, we then address them, just for order?
I suggest we take about 3 questions at a time, and then 2 sets of 3 questions each, and then we can round up.
So that's fine, sir. So we have one question here from Mr. Shedrak Siketi. He says, from core litigation to energy law, what are the likely pitfalls to look out for in such a situation? So that's for Shedrak Siketi. Let me say, okay, there's one question, I think say from Badebo. Good afternoon, NSC. My question is that for a law student seeking admission into the Nigerian Bar Association in 2025, I don't know, what are the opportunities in the green economy and energy transition? Okay.
Yeah, I think that's the first question I was at.
Okay, good. So one anonymous attendee. I wish LSMTO would list out some sites to gain more trainings. No, I don't think this is for us. So I think we have just 2 questions now. Okay, there's a third question from Mr. Felix Akbowowo. He says, just a minute, please. I take Akpofuri Paul. He says the energy transition. Okay, sorry. Akpofuri Felix. Good afternoon, our respected panelists. In view of the observation made by you that we currently have the capacity to generate 20,000 megawatts, but that our grid cannot carry that capacity, what is your suggestion for enhancing our capacity to accommodate additional or potential energy being generated or likely to be generated. Regards, Felix Akor. That should be this. So I think I go for the last one by Paul, by Akofure Paul. Take that question, then we'll go for the answer. Well, energy transition opportunities, especially in Niger Delta region, is it possible to tap into these commercial trends in the oil and gas sector? So I think we can take those questions for now.
Mofe, I think you should go.
Okay. All right, sir. So I think the first question had to do with opportunities for a student going into law school next year. I think on that, my first sort of response would be that the primary focus should be, one, getting in and getting beyond the bar exams before, thinking too much about some of these more complex areas of practice. So that, I think, should be the primary objective. But also, having said that, the opportunities that a student who wants to go into law school next year, who I then imagine will not be called to bar until 2026, would be to set yourself well for internship opportunities in law firms that practice in this area in the country, so that you can gain an initial opportunity to interact with the subject matter, and then you can sort of decide for yourself how you want to build your career from there. But as a lawyer just getting called to bar now, I don't think that you will find in a complex practice area such as this that you will find much opportunity for interaction unless you find yourself in a firm that does that sort of work already. The other point was switching from litigation practice to energy law. I think this question may be answered from two different angles. The first one would be whether you are in employment in a law firm, in which case the opportunity to switch really is dependent on the kind of work that your firm already does. And I think that may be an internal matter for your firm to deal with. The second is if you run your own practice and you want to move from a core litigation practice into energy law, I think the first thing that you need to do is to build capacity in that area, because you need to know what you're doing, particularly if you want to abandon something that you already do and you are known for doing. You need to build capacity in that area and ensure that you operate from the perspective that there is available work for you to do in that area. Energy law is fairly new as far as Nigeria is concerned. It's maybe 20 or so odd old in the legal practice sector, but there is a lot of deep experience area, which there is a lot of deep competition also. And so you probably want to come into it from a baby steps perspective and see what you can get and then sort of build up in that area. Because because it's sort of a growing area talking about today, I think that you will find that there's an overflow of work, especially for practitioner who is not coming in on an experience. And so that's probably the way to think about it. It's a long game. Those who are doing it now have been at it for several years and did not sort of arrive at that point today. So I hope that helps in that respect. For enhancing grid capacity, I don't think that the question on enhancing grid capacity, because we have an oversupply of power, I don't think that excess power is going to ever make it to the national, because I don't think that the investment that is required to enhance the national grid to take power is going to happen, which is one of the reasons why I think that the federal government found it easy at this point to liberalize regulation of the power sector to allow the states to come on board. So as I said earlier, I think when the states are better set up, those who are sitting on that power now and have no buyers to take it off them are going to start marketing that power to the states. And so you need to have, the states have an incentive now to incentivize investments within their states so that you can have buyers or potential buyers of that power within the states. And one of the examples I have given is large residential clusters. If a large residential estate that needs power, there's an opportunity now, once there's a legal framework in place for those kind of large estates to buy power and be able to use it and potentially get to 24-hour power supply. So I think that power will eventually go, and that will incentivize others to continue to generate more power that can then again be bought. And we may then get to the point of 200,000 megawatt supply in the future.
Okay, let me just add to what Mofesomo said. I just want to comment on the side of switching or whatever. What I generally advise young lawyers to do is your first 5 years, try and do everything. Try and expose yourself to as many areas of law as you have the opportunity to. Then after 5 years, you can begin to narrow your focus to what I call general specialized areas like energy, telecoms, banking and finance and all that. Then after 10 years, you can then decide, okay, I want to take a plunge into an area and then dive deep into it. So there's nothing wrong with staying with your litigation and at the same time honing your interest in energy law. By the way, Mofesomo does both. Mofesomo, you didn't say that, man.
Yes, I did.
I had mentioned this in my recitation of his profile.
So it doesn't have to be one or the other.
It doesn't have to be one or
Yes.
the other. Yeah.
Yes.
Exactly.
Okay, so so the chairman of the branch, Tado Papo, I think is raising his hand, so he needs to communicate with us. So please let us yield the floor to him. Yes. Yeah. Okay. Chairman, can you hear us? Can you please unmute and speak? Unmute yourself.
Okay, please, can you hear me now?
Okay. Yes, we can hear you.
Can you hear me now? Yes. Good afternoon, everyone,
yes,
especially our panelists. I appreciate all of you for the wonderful conversation that we've had. I've been on the road coming from Port Harcourt. I went for a matter yesterday, and I traveled to Port Harcourt yesterday, and I'm just on my way coming back now. I just entered into my house now. But I've been following whilst on the road the conversation that has been ongoing since. And I must appreciate our learned senior, Sir George Etomi, for his wonderful contribution. And learned Sikh, I appreciate you so much, very much. I'm listening to what is happening, but it's obvious to all of us in the practice that we are far, far beyond core litigation. The world is going very fast, very fast-paced. And if we do more, like as in Warri division here, we are core litigators. And I think if we remain like this, the profession will outlive us. So I think it's the best thing that this conversation is ongoing, and more areas of practice are being open for everybody. But we cannot key into this if we don't involve ourselves in knowledge. Like what our learned senior said, Mr. George told me that knowledge is power. Yes, that's a truism. Knowledge is power. We must build on our knowledge, and also increase our capacity to get more. And so I'm listening to the conversation, and I appreciate all of you here for the branch. Thank you very much. I welcome to this webinar process that we're doing. ARUOTURE, please continue. Thank you very much.
Okay, thank you, Chairman. Sir George Etomi, like he said, and let's say there are two questions. I think perhaps we should take them, round up there. Should I go ahead, sir?
Yes, please.
Thank you, sir. ML Aruna, NEC issued the order on the transition to bilateral trading in the Nigerian electricity supply industry. As a lawyer who is interested in energy law, how can one key into this area of practice? The second question is, what are the local content requirements in the power and energy sector? Yes, and there's one okay, and then there is no doubt that one of the factors potential clients consider is experience. What are the chances available for a young lawyer with experience in the oil, power sectors to be looked out for by the players in these sectors? I think he meant, what are the chances available for a young lawyer without experience in the oil/power sectors? I think that's what he meant, to be looked out for by players in this.
Okay. Mofe, please indulge me. Let me answer the last question, and then I'll leave the other two to you, because I have to run off now for something else. So I won't be around for the close.
All right, sir.
To the question about how does a young lawyer get recognized, you have to pay your dues. If you were here at the beginning, I said, go and seek for the knowledge, join section or any other section on business law committees that do energy. First of all, get to be known amongst your colleagues first, because you can work. Who says you can't work with a colleague on a matter? Because the recognition starts from there. Nobody experiments, no client experiments on such sensitive subject areas as oil and gas and power. They want value for their money. So to be known, just show up, ask questions, go and read. Luckily, you have everything on your phone now, and then begin to hone your skills. For those of you in law school, I think Mr. Mofe had advised, if you can work your way to firms that are known in this area, you can even begin to get your internship experience in these areas. Everything is slow, but must be slow and deliberate. I just want to please advise, don't be put off. Every one of us you see here, me, Mofe, we didn't start overnight. I told you my experience. I mean, at the age I got into power, everybody would generally have retired. But at that time, there was an opportunity. I was particularly miffed at the fact that one of the negotiations we went for, the lawyers who were supposed to be working with for the client did not even want to sit on the same row with us. You know, it's this sort of international intrigue that goes on in these things. If I was put off by that behavior, I would not be where I am today. I saw it as a challenge. And the rest, like they say, is history. So please, there are building blocks, you can't avoid them, or just keep at it. Webinars like this, and I must end by commending all those of you who organized this webinar. That's the way to go. That's the way to go. We have no other way but to ensure that we get a foothold into these so-called esoteric areas of practice. Thank you, and I must leave. So, Mofe, thanks for being here, and branch chairman, thank you for your compliments, and every participant, we truly appreciate you. Thank you.
Thank you, sir.
Thank you very much, sir. Thank you, sir. We're very grateful, sir. Thank you. Okay, so I think.
Okay. Yeah, I think
you answered the last question, right?
Yes, I will. And I think the last question was that I have here is trying to get in with the
Nigerian electricity supply industry.
Yeah.
As a lawyer who is interested in energy law, how can one key into this area of practice? I don't know if you can see it from your side.
Yes, I see that question. So for that's an area of regulatory law and also sort of core energy law. My advice to somebody who wants to go into that area, one is to go back to thought leadership, which I had spoken about earlier. You cannot. I think in trying to enter the market, it's difficult for you to pick and choose the type of work that will come your way from that particular sector. Whatever it is that you can learn first, you need to sort of do your best at it, and what can come for you subsequently after that. If the transition to bilateral trading regulations or order is something that you're interested in particular, advice would be that you write on it as much as you can. And so using the internet today, if somebody was to go on Google tomorrow and require some information on that, let it be one of your articles that comes up. And so people start to reckon with you as a subject matter expert in that area. And when they need advice or they need guidance or whatever it is that they need, they start to think of you, and ultimately they can reach out to you in that area. I think altogether, just to wrap the general thoughts up, I would say that it's good to think about the fact that just as law is in general, it's a long game. It's a long old game. And so nobody should really expect that anything would happen quickly. Those who have arrived at the point that they are now had been sort of playing that game for a significant amount of time before they can get to where they are. That's one. Two, speaking in terms of lawyers within, I would say maybe the branch now within the state, is that from a strategy point of view, you want to move from a place of competitive advantage. And you need to understand what the type of work is. So it's nice to say, I want to do electricity law, or I want to do energy law. But if you think objectively about how that type of work is and your placement to deal with that type of work, you need to be able to answer some hard questions. So I can give an example. If you need to do due diligence on a transaction for maybe an acquisition of a company in the sector, sometimes you need to commit 3, 4, 5, 6 lawyers to that due diligence exercise alone for a few weeks. Is your law firm set up to be able to do so? Can you commit 4 to 6 lawyers for 4 weeks to go and do that? If the answer is no, it means you're never going to get that work, right? So we should then be thinking about the fact that if we want that kind of work to come to us, how can we better equip ourselves to do that? You want to start thinking about partnerships. And so partnerships, 2, 3, 4 firms come together. Mr. A does litigation, Mr. B does this, and Mr. C does that. Because sometimes also when a lot of this work is done, you need cross-functional teams. You need a team that has somebody who's experienced in litigation, because the due diligence involves review of litigation. You need who's good in corporate, because the due diligence requires some corporate law review. You need somebody who also knows electricity or power law, because this side also involves that. And so there's some more foundational things that need to be done that will put you in good stead to be able to attract that kind of work. Bearing in mind the fact that competition is likely a more established and experienced firm in Lagos or Port Harcourt or Abuja or wherever, or an international firm with 1,000 lawyers in London. You need to be in a position where you can compete better with those types of guys. And there's a lot of groundwork to be done before you can start to get the kind of glamorous work that comes in, because it's highly complex, it's highly specialized, it's very well lucrative, or it could be very lucrative. But if you don't do any of these things on a foundational level, the client is not likely to their money, even if he was. Thank you.
Okay, thank you. I think that's all for the questions. Once again, thank you very much for being with us. Let's see. We have, I believe, all been blessed.
Thank you.
And power packed with all the resources that you given to us today. So we want you to be one of our speakers. I think so. It's good to let you on hand. So Warri loves you, and Warri wants to see you again. For participants, for participants, their presentation slides will ensure we send them to